welcome back. I hope that you have enjoyed your short coffee break, but we are on a fairly tight time schedule, so we have to continue with this first panel. Our next speaker will be Professor Lisa Spagnolo from Macquarie University in Sydney, Australia. I hope I pronounced the name of the university well. She's involved in an extensive research on the CISG and on comparative law as well, and perhaps very importantly, she was the rapporteur for the advisory opinion number 16 on the contract exclusion under Article 6 of the CISG. Today, she will speak to us about the issue of contract formation under the CISG. So, without further ado, I leave you to Professor Spagnolo.
Thank you very much for that. Today I'll be talking about Articles 14 through to 24. I want to, before I start, thank the university for being such gracious hosts and for everyone to come here and to listen to more about the CISG. I started out as a Vismut student. That's where my interest in the CISG grew from. And I've never stopped looking at it since, really. I have looked at other things as well, but also comparative law and the CISG, it's a really interesting area to get involved in. What I'll be speaking about, of course, is formation of the contract. Not only formation of the contract, but these rules in Article 14 through to 24 also apply to any agreement such as an agreement to modify the contract by the parties that might be made later on after the contract is formed, or even an agreement between them to terminate or avoid the contract. The same rules apply in regard to that. So I'll just go through these briefly, but remembering what, of course, Professor Schwenzer said about the possibility that when you're looking at formation rules, you might also be looking at what terms have been agreed as part of that. Of course, it's not only the formation of the contract, but it's the formation of the contents of the contract, the terms of the agreement, whether there is an agreement to be obliged to supply information, for example. Before I begin, one question that often arises and is sometimes relevant in the moot also is whether or not these rules about formation that appear in the CISG are actually relevant to the agreement for dispute resolution, the arbitration agreement. And there is a difference of opinion about this regarding whether the formation rules apply to agreement to arbitrate or forum selection, so choice of a court, for example. The majority or prevailing view at the moment appears to be yes, they do apply, except in regard to one matter, and that is anything special to, say, an arbitration agreement, lex specialis. So, for example, the form requirements that you might find in the New York Convention or in the Model Law on International Commercial Arbitration. So the writing requirements, for example, they would apply in addition. Remember also that there is Article 6, the option to opt out of the CISG applying. But to enable parties to do that, they first have to reach an agreement to opt out of the CISG applying, and therefore these rules apply to determine whether that agreement has been reached between the parties. So what do we need for an agreement under these formation rules? Obviously offer and acceptance, but how that happens and how terms are incorporated is the real question. So there are a number of things that the CISG requires within the definitions of an offer and an acceptance. But what it doesn't require are some of the things that we find in domestic law. Obviously, with my accent, I'm from a common law background from Australia. One of the things we would require under our domestic law would be for formation of a contract, we'd need to find there's consideration. That's not necessary under the CISG. In some civil law system, you need to show cause or causa, but that's not required under the CISG either. All that you require is to satisfy that there has been, in some shape or form, an offer and an acceptance. But that can be quite a fluid thing. It's not necessarily a 1-2 proposition. So to begin with, let's look at offer. So here, I'm sorry I don't have any nice slides like my predecessors had, but you have the provisions in front of you. And if we look at Article 14, we see the definition and the requirements for an offer. So in Article 14, we see 2 sub-articles. I won't go through those in detail, but basically Article 14 is dealing with the question, is there an offer? The words that are used in the offer or proposal itself are not determinative of that question. What is determinative of that question, is there an offer, are the 2 elements that are mentioned in Article 14.1. The first element is that the proposal must be sufficiently definite. And the second one is that it must manifest in some way an intention to be bound if the proposal is accepted. So those are the 2 things we need. If it's not an offer, then it might be an invitation to make an offer, which is something different. It's just saying, come and make me an offer. So let's go through the 2 essential requirements, because this is what's going to tell you if there's been an offer and what's in the offer, and that determines what the terms might be. The first requirement I mentioned is that it be sufficiently definite. So what does this mean? Essentially, any of the essential terms that are absolutely required must appear in the offer. So this is things like, what are the goods, what is the quantity, what is the price, and who are the parties. To work out if that detail has been specified in the offer or proposal, we look at it from the perspective of a reasonable person, usually. So would a reasonable person standing in the shoes of the addressee of the proposal, the person receiving it, would they think those details have been mentioned? Would they think those details have been specified? Is that what they would understand if they stood in their shoes in those circumstances? Now, this understanding, which we get as the standard from Article 8.2, is influenced by all of those things that Professor Schwenzer mentioned. It's influenced by the past practices between the parties. So if they've had previous dealings, that will be influential on what is included within the proposal. And also by trade usages, what is normal in international usage in that trade or sector. So those come from, of course, Articles 8.3 and Article 9. We can also see from subsequent conduct what might be considered by the parties to be included in the proposal, what terms are included. So we know that from Article 8.3. The parties' subsequent conduct, what they do after the contract is supposedly formed, can influence what is considered to be in the proposal. So moving now to the price and the quantity, these things can be defined just by specifying a method to determine those things. It doesn't actually have to say the price or the quantity. If there's a formula or a way you can figure it out, that is good enough. So you could say this year's crop, this year's harvest, and that will be sufficient to say the quantity. You could refer to a price list. That's sufficient to say what the price is. And also remember there's Article 55, which can fill in the gap if there's no agreement about price, to say there's a reasonable price. As to the goods, that too just needs to be very basic. It doesn't need to detail every feature of the goods. Those things can be implied in a sense. So if it doesn't mention the colour of the goods or some feature, then that can be worked out by what is reasonable. The parties must also be specified, and this is actually quite important because, as you'll see from Article 14.2, if there's no specification of who the proposal is addressed to, at least one or more parties aren't specified, then that probably just amounts to an invitation to make an offer rather than an offer itself. So that's what's needed to be sufficiently definite. You need to have the parties, the goods, the quantity and the price in some way. But if it's clear from the parties' previous practices between them, from their previous dealings, that some other detail besides those ones I've just mentioned is really vitally important to them, then that might be something that is an essential term that is included or required within the proposal. So that could be anything. It depends on what the past practices of the parties are. So obviously here we might think about what they previously considered to be very important in their past dealings. And that might be a term that should be in the proposal or maybe even is implied within it. So that would be then added to the list of what is sufficiently definite. And
Professor Spagnolo,
yes?
One question on that. It's very interesting when you mention about all the essential elements that the proposal must have to qualify as an offer. And when you mention Article 14 and all these elements, and you refer to the way it's complemented by Article 55, I do remember quite a dispute. In some countries, the issue of the price to be certain, not only determined or determinable, but be certain, was crucial. And I think in the United States that was not very well understood because open price contracts are very common in the United States. What is your view now that we have discussed the questions of validity being something that it's out the convention, but if it's envisioned by the convention, it may not. What's your view on that issue of the price? How important is that issue as a descriptive, the intention to be bound?
Yeah, that's really interesting because this comes up in my domestic law course that I teach on Australian contract law because we teach the CISG alongside the Australian contract law. So the students quickly learn that, at least in my view, when we get to the element of intention to be bound, that is where this idea of certainty comes in. If it's too vague, then it probably doesn't manifest an intention to be bound by the person making the proposal. So if it's way too vague and fluffy and uncertain, then it's probably not really intended to be binding by them. It's probably meant to be a negotiating point. And I think really when domestic law talks about validity, and this is the case under Australian law, if it's not certain enough, then it's probably not forming an agreement, that really it's just teasing out one aspect of intention to be bound. So for the CISG's purposes, that's all wrapped up in this element of intention to be bound. At least that's my view. And I think Article 55 is there to save those contracts that just don't mention the price from being considered to be too uncertain. So intention to be bound, I'll just say a few words about that and then get on to some more interesting aspects. Obviously, this is where the person who is potentially the offeror has to be at least manifesting an intention to be bound. And because we're only dealing with commercial parties here, frequently they are going to be intending to be bound, provided that the offer is sufficiently definite. It usually goes together with that. So we also test this by an objective test, and we look at it from the shoes of the addressee again. Would they understand this proposal to be demonstrating an intention to be bound, taking account of, again, usages of the trade and past practices? The wording of the proposal here is really important too. If it says in the proposal something like, this is a non-binding offer or something of that nature, then it's most likely going to be interpreted as not being intending to be bound. Or it's a letter of intention or a memorandum of heads of agreement or something like that. It may be not intending to be bound by it if it's accepted because it's just a preliminary stage. One thing that comes up in the current context of trade, of course, is interaction with websites. So websites, I think, can manifest an intention to be bound if it allows for interaction and allows you to place an order and shows availability of goods, for example. Something that comes up is whether or not certain terms have been incorporated into an offer, or for that matter, an acceptance. And the incorporation of standard terms often is used to illustrate how to answer this point. But standard terms might be incorporated because they're part of a framework agreement, for example. So if something is within a framework agreement, it may be incorporated into an individual agreement simply by this process of standard terms being incorporated. It might also be incorporated because the terms are contained in an external document, such as, for example, Incoterms or UCP, or model terms that are in standard forms that are put out by trade associations, like, for example, GAFTA GAFTA 100 for grain transactions. That's the trade association for grain transactions, and they have a set of standard terms that parties can just incorporate by reference. They just say GAFTA 100. That's it. So how do these get incorporated into the contract under the CISG? This is a question of formation. So the formation rules apply. And the CISG, unsurprisingly, has developed rules or interpretations of its rules that provide for when this successfully gets incorporated and when it doesn't. So the two requirements are there needs to be some sort of reference to the standard terms, and the second one is that the offeree is sufficiently made aware of those terms. How that works in practice, the reference to the standard terms generally has to be sufficiently clear. That goes without saying. But if they're really well-known ones, then it doesn't have to say much. It can just say, for example, Incoterms CIF. That will be sufficient to be a clear reference because that's well-known. If the language is a little bit ambiguous, that might be a problem. And the second requirement is that idea that the addressee or the offeree needs to be having some level of awareness of what those standard terms are, but that's going to vary. So, for example, if those standard terms are very well known throughout the world, like Incoterms, they're used all the time, then probably the reference Incoterms CIF will be enough. If the parties have dealt with each other before, and those standard terms, say the seller's standard terms, have been supplied to the buyer, then that might be enough because by referring to the seller's standard terms, they've already been made aware of what those are by previous dealings. So they don't have to resupply the standard terms to the buyer again and again every single time. They've already done it once, hopefully recently, and they've already been made aware of them. But otherwise, the level of knowledge that is required about what the standard terms actually are is governed by the idea of either reasonable opportunity, according to some authors, that you need to give them a reasonable opportunity to become aware of what those standard terms are, or a higher bar, which is the majority view, that you must satisfy something called the making available test. So what this means is if you want your standard terms to apply and be incorporated as the terms of the contract, you would need to provide them in some way, to take positive steps to make them available to the other party. So the burden is on the party who wants to have the standard terms or any terms incorporated to make them clear. The Advisory Council in Opinion number 13 does a really good job of explaining this test. How do you satisfy this test? In practical terms, well, you could send the standard terms to the other party by perhaps attaching them to an email, perhaps printing them on the reverse side of the form, enclosing them with a letter if you want to use the old-fashioned ways, or maybe a hyperlink in your email. Those things will probably do the trick. But other ways perhaps are possible. You might hand them to the other party personally, face-to-face, or display the terms in a meeting room where you're meeting with them. One controversial question is whether displaying the terms on a website would be enough. Perhaps like a pop-up thing that displays the terms. Whatever way you use, as the Advisory Council says, you must make sure that those terms are at least available in a way that the other party can retrieve them and, if necessary, save them for later reference. So you have to have them in some form that they can do that. So that's going to be important. And you also have to allow sufficient time for the other party to read them. It's no good just saying, oh, well, look, the terms are up there on the shelf somewhere, go find them. So here, that's why a hyperlink works really well, because it makes it very easy for the other party to find them, those terms. Just click on the link. So because the burden's on the party who wants their term to form part of the contract, they will need to show they've taken enough positive steps to make it easy for the other party. They haven't led them on a sort of a trail where they have to hunt for the terms, for example. So it wouldn't be sufficient, for example, to say, probably wouldn't be sufficient, for example, to say in an email, this is the web address or this is our website where you can find our standard terms, if you don't make it easy enough for them to find it. If they have to click through a number of pages to find the terms, that's probably not good enough. That doesn't satisfy the burden that is on the party who wants the term to make it into the contract. So that's what we mean by making available test and the sorts of things that might work and might not work. The burden is always on the party who wants to have their term in. But this idea of making available is really influenced by a number of things. Again, you always have to keep in mind other factors. Have you made it too difficult for them to find these terms because of the language that you used in referencing to the terms? Is it in the language of the other party? Is it in the language of the negotiations? Have you made this font too small that someone like me is unable to read it? What about the usages and the practices of the parties? Have they always contracted on the same terms before? Are they aware of those terms? Was it recently that they did so? So those things will all be influential on whether you've satisfied that test. Once an offer is made, it can come to an end, of course, by either being withdrawn or revoked under Article 16, or it might be terminated under Article 17, or of course it can be accepted and a contract is formed under Articles 18 and 19. Article 15 I'll only mention briefly. It does two things. What it tells us is what point in time an offer becomes effective at law, and that's when it reaches the offeree. The second thing it does, and that's in sub-article 2, is that saying that you can withdraw an offer, even an irrevocable one, provided you beat the offer in time. For example, in the old days, you might have posted an offer, but then you ring up on the phone and say, hey, I want to withdraw my offer before the letter arrives. So that was possible, but these days, very unlikely because most communication is, of course, electronic, so the time it takes to reach, you're not going to beat the offer. But it is worth noting that the offer will never take effect and the terms within it can never be accepted if it never reaches the other party. And Article 24 is where it tells us what reaching actually means as to the timing when it takes effect. Okay, I want to move to Article 16 very briefly. This is revocation of an offer, but it's only ever going to be relevant once the offer takes effect. In other words, after the offer reaches the other party. Again, this article contains two sub-articles. The first one, sub-article 16.1, tells you when you can revoke an offer that has become effective. And Article 16.2 tells you when you can't revoke an offer that has become effective. Very easy to understand, but similar to Article 7, this one caused a lot of controversy when the drafters met in Vienna to draft the CISG. There were differences of opinion, again, often falling on civil law, common law, dividing lines. Super controversial at the convention, but in practice has not proved to be controversial at all, really. So let's just start briefly with Article 16.1, when you can revoke an offer that has been made. And it says this is okay, provided that the revocation, the notice that you want to revoke, reaches the offeree before they send their acceptance. So provided they haven't sent the acceptance, you can revoke. That's okay. Then we turn to sub-article 2, which says when you can't revoke. And this is in two situations that the CISG says, look, you just can't. The first is sub-article A, and this is what we call fixed offers. In other words, you've basically manifested an intention within the offer that you're not going to revoke. And offers that manifest this intention to be irrevocable can't be revoked. They just have to wait until they lapse. So this is where you might say, for example, the offer will be held open until the end of the month. Bad luck, you've said it. It's irrevocable until the end of the month. Now, this might seem uncontroversial to civil lawyers, and I'm not sure if you have a similar rule under your own domestic law. You do? Okay, guessed right. But that's not controversial to you, but I got to tell you, in common law countries, this is super controversial. And my students are like shocked when they learn the difference between our domestic law rules on this and the CISG rules. And I always ask them, which one do you think is the best rule? Now that you've only learnt both of them side by side together and you don't know, you haven't thought about this, what do you think instinctively? And they always say, the CISG rule makes sense. You've said you're not going to revoke, essentially, so why should you be allowed to? It's all wrapped up with this idea of consideration under the common law. You don't need to worry about it because it's not part of the CISG, but that's where the controversy comes in the common law. And then the other situation where you cannot revoke, the second one, is under subarticle B of 16.2. And this is where the offer has induced reasonable reliance by the addressee on the offer. Now, this is really interesting for you guys because it really manifests very clearly a general principle of the CISG. And as you would know, under Article 7.2, you can use general principles of the CISG to interpret any perceived gaps in the CISG, to fill those gaps, right? So this general principle is known by a Latin term, but in English you would say general principle prohibiting contradictory behaviour. You can't act one way and then act the complete opposite way. So this general principle is very useful and it reappears in other articles in the CISG too, not least of which is Article 29.2, which deals with the effectiveness of a no oral modification clause. So if parties put such a clause in their contracts that you can't amend the contract except in writing, whether or not that can be overridden or not depends on reliance and contradictory behaviour. So this same principle applies in 16.2b and in 29.2, and we can use it as a general principle of interpretation throughout the CISG. Very interesting. So the question that you might be asking yourself by now is, what happens if the offer can't be revoked, whether under 16.2a or b, but the offeror wants to revoke it? They try to revoke it, maybe unsuccessfully because they don't have the right to revoke it. What happens then? Well, under the CISG, it means that the addressee has the right to accept the offer and force the contract to be formed, and then to sue for breach if the other party doesn't want to perform. That's their remedy under the CISG. If they don't form a contract, then arguably, according to some cases, they might be able to sue under the domestic law for a reliance-based type of action. In common law countries, that might be something like estoppel for reliance damages. In civil law systems, it might be the equivalent of culpa in contrahendo. So whatever that reliance-based thing is, which differs between the different jurisdictions. Obviously, you can't revoke also if the offer has been accepted. That's too late. Very briefly, Article 17, easy to understand. It simply covers rejection of the offer. A way that the offer can be terminated is simply by being rejected, whether that's outright, no, we're not interested, or by making a counteroffer. So a counteroffer will be a rejection under Article 17. And of course, an offer can simply lapse by time elapsing. And then we come to the other side of the formation coin, if you like, that is acceptance. So Article 18 deals with acceptance, and also Article 19. Article 18 has 3 sub-articles, and I'm not going to deal with Article 18.3 for today because I want to keep it straightforward. So I'm just going to concentrate on the most important ones, which are Article 18.1 and Article 18.2. To prove that there is an acceptance of an offer and therefore formation of a contract is obviously the burden of proof there will lie with the party alleging that it was accepted. What do you need for an acceptance? Well, Article 18.1 tells you straight away that you need assent to the offer. But silence or inactivity, at least alone, is not enough. Article 18.2 deals with the timing of acceptance, which it can be really important in many situations in practice. And again, it uses that notion that the acceptance must reach the offeror. That's the time when it becomes effective, which is the time that the contract will be formed. It also says when this must happen by. So this brings up some pretty interesting questions. It must happen, the acceptance must actually become effective within a reasonable time after the offer. What is reasonable can depend on the goods themselves. Are they perishable goods? That would change what is a reasonable time. Are they seasonal goods, like maybe Christmas trees? That might change what is a reasonable time. Or, alternatively, if a time frame for acceptance is stated in the offer, then it must, of course, be within that time frame. So if the offer says you must accept by 5 p.m. on the 10th of April, you must obviously get your acceptance to be effective before that time. But what is really interesting is that Article 18.2 actually specifies a different time for oral offers. So it says if the offer has been made orally, then you must accept immediately, which is really interesting. And I'm going to return to that more in a little while. But first I want to touch on a few important points about acceptance. I've already mentioned that acceptance becomes effective when it reaches the offeror. When is this magical moment when the formation of the contract going to happen? Generally, what we mean is the time when the acceptance is received. Article 24 tells us this. And that means we're using a receipt theory of acceptance or of when it takes effect. Once the acceptance takes effect, you can no longer withdraw an acceptance. That's it. I used the term assent before. What do we mean by that? Obviously, it's agreement to the terms that are contained in the offer. When this becomes interesting is that it means if you're agreeing to the terms in the offer that you cannot, in your acceptance, include any terms that are materially different to the terms in the offer. Because if you do include terms that are materially different, that will be a counteroffer. Assent can also be in the form of either words or conduct. It can be purely conduct. For example, instead of saying, yes, we agree, you might simply, as the buyer, pay the price that's been asked. But whatever form the acceptance takes, whether it's words or conduct, it becomes effective upon reaching the other party when they find out about the conduct, for example. And it must manifest an intention to be bound. It must do that. Now, of course, you can use any method to accept an offer unless the offer has specified there's only one particular way that you can accept. So it might say, for example, you must accept by post or something crazy like that. But unless the offer has restricted the method, you can use any method. So you could accept electronically, and that's obviously how people usually do that. The acceptance could be restricted in other ways, I didn't mention, but it might be restricted by the framework agreement, for example. That can set limits on how you can accept or how communication can happen. But one thing that's interesting is that if it's been an oral offer, as I said before, acceptance is required immediately unless the circumstances indicate otherwise. So if I offer you a certain amount of oranges for $4 a crate and I say you have until tomorrow to accept and we're face-to-face in a conversation, then it's easy to understand that the idea that it's an oral offer you must accept immediately, straightforward. But where it really blurs the lines is between what is meant by oral and other methods. Where does the line between oral and other methods of communication stand? Because that makes a difference as to whether you need to accept immediately, and also a difference to timing under other provisions of the CISG. Now, is it a difference between oral and written? Some people think so. But we really need to ask the question, why does the CISG even make this distinction between oral and other methods anyway? What is the point of this distinction? And the reason appears to be, from what I've seen, is that back in the 70s, of course, there weren't any other real ways to communicate immediately. When you were talking about a back and forth conversation, it was usually oral, whether it was on the phone or whether it was face-to-face. So you're usually a back and forth conversation where you was back and forth immediately replying was by voice. So oral makes sense when you think about it that way. But now, of course, we have other methods of communication which allow us to speak back and forth immediately, even if we're on other sides of the world and not using our voices, right? So because those methods don't involve our voices, we need to interpret the word oral to determine where that line is in terms of communication methods, because we have WeChat, we have WhatsApp, we have SMS, we have websites with live chat boxes and other things. What I argue is really important in determining what should be considered oral and therefore subject to the rules about immediacy of acceptance is this idea of immediacy. It's actually the immediacy of the conversation that really matters, not whether it's by voice or other means. And that, I think, is why the CISG singles out oral communications for special rules under the formation provisions. It's because when you have that back and forth immediately, that immediate idea, you build up this expectation that you're going to get an immediate reply. And that's why it says acceptance has to be immediate if the offer is made orally. So my argument is that rules about acceptance needing to be immediate for oral offers also applies to online chats, provided that the conversation is punctuated between responses by, say, seconds or minutes, but maybe not hours and days. If there's a long gap between the responses, that probably doesn't qualify as an immediate kind of dialogue. So those rules about oral communication probably apply to chats, provided they are given that quality of immediacy by how often parties are responding. Email, on the other hand, yes? Thank you.
Just wanted to ask, you are saying about messages. So if we are having an immediate chat, for example, we are writing each other in minutes, for example, and you make an offer and someone doesn't respond in 2 or 3 hours, does it make sense to take it as an rejection of an offer?
It may be that the offer simply lapses in that circumstance because it hasn't been accepted immediately, even though all the conversation up to that point had been immediate. So then if it falls within that rule about acceptances to an oral offer need to be made immediately or else they're not accepted, then that would probably, in my view, be the appropriate approach. It may be that the offer can be made again, but it's to say that that particular offer may not have been accepted. Yeah. But this is my view, and there are differences of opinion about this. So some of my colleagues believe that, all written responses back and forth should be classified as other means, not oral. Yeah. So, there's room for interpretation here, but I guess, again, as Professor Schwenzer said, we need to sometimes look at the policy or the idea behind what the rule was designed to achieve as the function of the rule to try and work out how it applies in current situations. Yeah. Thank you for that. So I want to contrast the kind of online chat situation to email. Email generally lacks that kind of idea of immediacy. Usually this should be treated, as with many other written communications, as something that falls within the rules regarding acceptance within a reasonable time or within the period specified. Just like any other online chat that is punctuated by days or hours of gaps between the communication, that should also fall within the rules on other means of communication, not under immediacy and oral communications. Article 19 is another compromise article. This one was trying to put in place a rule for acceptances that was more flexible than requiring an exact match between the offer and the acceptance. So Article 19 makes a start on this by saying that any acceptance will be a counter-offer and therefore a rejection of the offer if it contains any modifications to the terms that were in the offer. But what Article 19.2 does is steps in to try and do something a little bit innovative. So it says that despite the rule in sub-Article 1, there's still going to be an acceptance if there's modifications in the acceptance, as long as two things are satisfied. First of all, that those differences in the acceptance, those different terms or changes to the terms, are not material. And the second thing is that the offeror does not object very quickly to those changes, so they have the chance to reject them. So provided that is the case, Article 19.2 says, yes, a contract will be formed on the modified terms. So that flexibility is baked in to Article 19.2. It achieves something other than just a mirror image rule between offer and acceptance mirroring each other. However, the problem child is in Article 19.3, which says, however, modifications should be considered to be material if they relate to price, payment, quality, quantity, delivery, liability, or dispute resolution, which doesn't leave a lot of room for immateriality. It dampens down that flexibility that was baked in by Article 19.2. Now, the CISG is not something that is stuck in the past. It develops, and we now have developments that challenge this idea that 19.3 just rules everything out. Terms that are not different, not considered different, would be things that are simply, obviously, typos, errors, giving options or choices. Terms that benefit the other party will not be considered to be material differences. But most importantly, there's now a strong view that Article 19.3 is merely presumptive. It just creates a presumption that something is material, but that presumption can be rebutted by the individual circumstances, so the usages between the parties and their past practices. Their subsequent conduct might indicate it too. So we also have cases that have decided that a lot of different clauses, even though they were brand new in the acceptance, did not materially alter the terms in the offer because of the individual facts in the case. Things like an arbitration clause, things like standard terms and delivery vessel being changed. So there are a lot of cases that demonstrate you can actually prove and rebut the presumption in Article 19.3. And finally, in regard to the fundamentals of formation, I'll just briefly mention Battle of the Forms because it's one of those student favourites. Battle of the Forms is where the parties have gone, oh, everything's fine, let's just perform the contract, despite the fact that they have exchanged two very different standard form terms of their own between each other. They just either didn't notice or just thought, it won't matter. But it does matter if there's a dispute. So in such cases, really formation of the contract is not in doubt, but what is in doubt is what are the contents of the terms of the contract? What are the terms? So really you've got a choice between a number of different theories, but I'll simplify it down to say there's really favourite theories are last shot theory, where the party who gave their terms to the other party last is the party whose terms will prevail and make it into the contract. The problem with that view is that it does sort of seem a little bit arbitrary as to who wins, and it can be, therefore, somewhat unpredictable. And that's sort of not what we're aiming for with the CISG. There is also the knockout rule, which is a theory whereby the commonality between the two sets of terms is determined, what is common between them, and those form the terms of the contract, and anything that is not common between the terms just falls away. This approach has been favoured perhaps by, I think now, the majority of commentators, but not everybody. And also the cases are split between the two methods, although probably the more recent cases tend to be in favour of the knockout rule. The Advisory Council has indicated they favour the knockout rule as well in opinion number 13. Now, the Battle of the Forms is obviously relevant if you've got two different sets of standard forms, but I would argue that sometimes the theories and the thinking behind the Battle of the Forms might be useful for other interpretive exercises as well. So you might think about whether that could be useful in terms of interpretive situations that aren't exactly a Battle of the Forms, but might gain something from the policy thinking behind the Battle of the Forms. Okay, now the rest of the articles that deal with formation issues are Articles 20 to 24. These articles deal with the timing and effect of communications. I'm not going to go through them all, except to say what they do, and then I just want to spend a few moments on Article 24 because I think that's somewhat relevant. Article 20 is really about the period of time calculation, and it makes certain that this rule will displace any domestic rules about that issue. So things like from when does time run? If one party says, for example, you've got a month to accept this offer, when does that month start to run? Article 21 deals with late acceptances and puts in place some useful rules for that. And Article 22 deals with withdrawal of an acceptance that has been made. Article 23 is really interesting because no one's really sure why it's there. It's sort of useless. It just says that a contract will be concluded when acceptance takes effect. Well, thank you very much, but Article 18 already has told us that. Nonetheless, Article 24 is probably the most relevant of these particular provisions in regard to formation, and this is the one that tells us more about when a communication to do with formation reaches the other party. And here again, we've got this distinction that I was talking about between oral communications and other communications. So oral communications are said to be effective when they are made immediately, whereas other communications become effective when they are delivered. So there's rules about each one. Why is this even important? Well, it determines when the risk shifts between the parties in case one of the communications goes missing or something happens. I've explained before what I think about this distinction between oral communications and other, that it's a bit of a blurry line now, it's a bit fuzzy, and I talk about this a little bit more in the Mankowski commentary, which we're having a new edition coming out soon. But this idea of immediacy, I think, really explains the difference. You'll notice that all commentaries tend to say, for example, that even though voicemail, if you leave a voice message, that is technically oral, right? But that's not considered to fall in the oral category. And I think this idea of immediacy is the reason why. You don't listen to the voice message straight away. That's the whole point of a voice message. It's there to be listened to later on, right? But it's oral. So why does it fall in the other means of communication? It's because it's not immediate and it's not intended to be. Okay, so complications with these different methods and how we resolve them. I think this is where it gets sort of ripe for further research, may I say. All right, so oral communications obviously includes face-to-face, phone calls, and this idea of immediacy in chats, online chats. What happens when the message that you send gets lost from the thread? Well, with phone calls and oral communications, there's this sort of idea that it's only effective when you say something if what you said is perceptible to the other party. They can perceive it, they can hear it, they have a chance. And they appear to sort of get it or understand it. Even if they don't, and they're just nodding their head because they want to appear like they get it, but they don't get it. If that's the case, then you've done your job. You've done the best you can. If it's obvious they haven't heard it, then it doesn't count. Like if they're turning their head and they're looking the other way and they don't hear what you're saying. You know that because you're there. How does that translate into online chats? Well, if a message is sent by one party and it goes missing, what happens then? It's really intriguing to think about that. Is that an imperceptible message under the oral rule? Does it fall within that? I would argue that sort of needs to be sorted out by who bears the risk in regard to whose sphere of control caused the problem that meant it didn't get sent. If it's something to do with the sender's system, then maybe that's their problem. But it can be the other way around. Yes, Marko.
I had a question. Most of the chats nowadays have an option to unsend a message once you've sent it. So what happens if you send an offer, the other person sees it, he accepts it, but you unsend the message before acceptance or even after acceptance, and then you claim there was no offer?
Yeah, so this, I think, is really interesting on a number of levels. Theoretically, and this is not talking about how hard it is to prove, but theoretically, I think if you are the one unsending a message that you have sent, but the other side sees it, then theoretically it's within your sphere of control that the communication issue has arisen and it was communicated despite your best efforts. So it's almost like you tried to withdraw the communication, but you failed. And therefore, that sphere of control idea would be useful in sorting that out. But the funny thing is, normally we use that sphere of control idea in regard to the other means of communication, so emails and so forth. So this is where it's blurring the lines even further. But I think if they've seen it and they are able to prove that, then that would be certainly the risk that you bear in trying to unsend it. You may not be successful in doing so. So if the evidence is there, but the trouble is, how do you capture that? I guess, in a sense, the fact that you know about it is, in a sense, well, of course, that's evidence itself. How would you even know about it if it hadn't happened? If you can say what was said, then, yeah. But whether you can actually bring some other further physical evidence is problematic, perhaps.
So it's an evidence problem?
It's an evidence problem. It's perhaps not a problem of the theory so much. But, yeah, it becomes an evidence problem then. Yeah, so, I mean, the same thing is true, I guess, if you think about it in terms of oral conversation face-to-face. How do you prove it? Well, I heard it. Well, they say they didn't say it, but I heard it. Yeah, so it comes down to the same thing. So if we're okay with it orally face-to-face or by phone, we have to be okay with it on a chat level as well, I guess.
And if I may add a comment to this question and the discussion, I mean, I'm trying to understand what was the underlying problem that Marko had in mind when asking the question. On the one hand, if the message was sent, seen, and then unsent, it's a clear case of revocation of an offer, as long as it's not an irrevocable offer. Actually, this problem becomes a problem only if we're talking about irrevocable offers, and then yes, I agree with you, it's a matter of evidence and how to prove it, and I'm sure all of you have done in correspondence with your boyfriends and girlfriends print screens of important messages, so I suspect that this might be a resolution for this problem as well on the evidence level to some extent.
If you can't see it, it never happened. Okay, I'm going to finish with one more point, and thank you for bearing with me. This one is in regard to other methods of communication. So I mentioned before, other methods might include, of course, the mysterious thing that you guys probably have never seen before, and that is facsimile or fax messages that are sent on a thing like a photocopier. Don't worry about it. Post, the old-fashioned letters. Of course, email, but also chats that don't have that quality of immediacy, at least in my opinion. So these are considered effective once they are delivered. Okay, that is when they become effective. And this idea of sphere of control has become really popular in terms of who bears the risk if something fails with that delivery of the message. So with email, the idea has been when does it reach the other party? And the Advisory Council in Opinion Number 1 has mentioned that it is the time when the email becomes capable of being retrieved. Now, this deals with risk in the following way. If the email went to spam because you have a spam filter, that's your problem. The fact you didn't see it, bad luck, because it's your spam filter as the recipient that has caused it not to land in your inbox. It's your risk. If you've got an inbox limit and it's exceeded by this, that's, again, your problem. It's in your sphere of control. You didn't choose the right server or the right provider who provides a bigger limit. Likewise, if there are problems with the server and it's your server that's stuffed up, that is your problem as the recipient. If the sender's server stuffed up and didn't send the message, then it's their problem and they bear the risk of that. However, the question that I ask in my research is, how do we deal with current problems? Because right now we know that things are not held on one server, right? There are multiple servers holding this thing simultaneously. So when we say it's received by the server, that's not really relevant in many cases. There's backup servers everywhere and they all get the thing simultaneously. That's modern communications. And what about when we say your server or your provider has been the problem? What if both parties are sending and receiving emails with the same provider? For example, so many of us use, say, Gmail, right? What if both the sender and the recipient are using Gmail, but Gmail just has a problem one day and it doesn't send the email or receive the email properly, or corrupts the email? Well, how do you pin that on whose system it is? Because you're both using the same system. So I think these are current problems and I try to find a solution to these in my writings, but I think these are the things we're currently grappling with that haven't really been thought about when opinion number 1 was originally written. So that's what I have to say about formation. I'm happy to take any questions or we can discuss afterwards. And I will allow Professor Garro to take who I think has a much more interesting topic. Thank you.
If there are no questions from the audience, and I don't see any hands, I would like to thank Professor Spagnolo for shedding light on the contemporary challenges regarding the contract formation and for putting this whole issue into a comparative perspective, which is also very, very useful.
Thank you.
Thank you very much once again. And we now continue our journey through the CISG, and we have reached Article 25. So we'll just wait for Professor Alejandro Garro to take his seat.
Thank you.
Professor Garro teaches at Columbia University School of Law in New York, but apart from that, he also has an extensive teaching experience throughout Latin America, in Argentina, in Mexico, in Uruguay, in Guatemala, but also in Europe, in France, and in Germany. On a very personal note, Professor Garro was one of the first authorities in CISG that I've met in 2010 when Milena Jovanović gathered the Advisory Council to celebrate the 30th anniversary of signing the CISG. So I had the pleasure of listening to him in the discussions within the Advisory Council. Many new horizons opened to me at that time, so I'm sure that the same impression will get to you now. So Professor Garro, please tell us something about the fundamental breach.
Thank you very much indeed, Marko. First of all, the thanks, which is not only a formality to the University of Belgrade, to Marko Jovanović, Milena Jovanović, and of course Professor Vladimir Pavic also, who is here, and who hosted us 13 years ago in this same university where the Advisory Council met. I think it was the 14th meeting of the Advisory Council at the time. So we are very pleased to be here. I'm certainly the only obstacle between lunch and you and this, so I think I'll definitely be very brief. But as pointed, I think the issue that I thought could be chosen for my presentation, after you had quite an extensive presentation on the scope of applications, Article 1 to 14, followed by the formation of contracts between Article 14 and 24. And then what I think it was a very centerpiece, because it's in every of these provisions, is Article 7, which Professor Schwenzer discussed with you openly. And I think it's extremely important, not only for the mutis who are going to be arguing the case, whose facts I'm not familiar with, but I definitely think that Article 7 always plays a role. First, the distinction between the first paragraph on interpretation of the convention and the second one on gap filling. They are interrelated, but they are definitely different subjects. So I think that, of course, I would love to talk about Article 25 because it speaks about a new concept which is called fundamental breach. And that concept, I understand, of course, I've already learned a lot about your country and neighboring countries, but I understand that you have a Serbian law of obligations of 1978. Then you'd also have a draft civil code of obligations and contracts, and I understand there is a preliminary draft civil code also in the making. And I think it's very interesting because when I saw and I read Professor Jelena Perovic speaking about the law of obligations of 78, she mentioned that fundamental breach is not there, but then she does refer to the draft civil code, and she does refer to the draft civil code incorporating that notion of fundamental breach. So even though I am unable to make an encyclopedic detailed distinction of what Article 25 means, I think it's important for you to use this element of fundamental breach, to think that is a concept that was designed specifically to try to give an autonomous concept to an idea. And the idea was very much discussed in Vienna about how to distinguish between those contracts which actually warranted the nuclear option, the avoidance or termination of the contract, and those other types of breaches that the parties can well actually manage, get a remedy, either damages or price reduction or so many others, without having to do the termination. And I think for me, it's important for you to understand why termination, avoidance of the contract is something that is sort of a ultima ratio, they mentioned, the last chance, is because the idea that in international sales especially, where sellers and buyers are located in different countries, if you terminate, the consequence of termination is nothing has happened, restitution, give me back what I gave you, and I will give you what I received. But that is complicated in international transaction because you have to consider transportation costs, storage costs, and many other types of problems that actually in a face-to-face or a domestic legal transactions are much more simple. So the drafters of the Vienna Sales Convention said, how do we distinguish those breaches that are minor, not very serious, from those that are grave and very serious? And they invented the concept of fundamental breach. Of course, one of the main purposes of having the notion of fundamental breach is to make it independent, separated from what you understand what are the causes of termination under your domestic law. And I think following what Professor Perovic she says in her presentation was that you do have a provision in the Serbian law of obligations that says that if the breach is minor, it does not warrant termination. That the idea is definitely there, even if you don't have the concept of fundamental breach. The concept difficulty for the judges from Serbia and arbitrators applying Serbian law is to determine what distinguishes a minor from a serious grave breach. And that is a problem that also obviously attacked all the members of the CISG community, because to get a conceptual distinction between serious and non-serious breaches in the abstract is extremely difficult. And the idea why I thought it would be a good idea to speak to you a little bit about this is because these abstract rules, the rules is the breach, the remedy is avoidance or termination, or avoidance and termination is warranted only if the breach is fundamental, is related to a concept. And the concept we need to go to it and read it. And it's in Article 25 that you have in your text. I don't have a projection to do it, but you will have that has two different tests. One is what is called the deprivation test, and the other one is called the foreseeability test. And 25 actually, in very artful, simple words, I would say, mentions the both, and I think that is worth quoting them at least, because it says a breach committed by one of the parties, and you see it works for both, buyers or sellers, is fundamental if it results in such detriment to the other party as substantially to deprive him of what he is entitled to expect under the contract. unless, and here comes the foreseeability test, the party in breach did not foresee, and a reasonable person of the same kind in the same circumstances would not have foreseen such a result. It doesn't tell you what is the timing. What do you mean foreseeability was not, what, the damage could not have been foreseen? At what time? At the time of conclusion of the contract, at the time of the breach, or some other time later on? Article 25 doesn't define that. The weight of authority, majority authority says, and I think that on that sense, commentaries are not in disagreement, but courts sometimes are, is the time of conclusion of the contract. Because it's at that time when the party in breach could have predicted, well, if I actually breach the contract, what could the consequences be? So that's the idea of fundamental breach under Article 25. Mind you, not all legal systems agree with that. In mine, for instance, in the Argentine Civil Code of 2015, and there is a Chinese Civil Code of 2020, now recently, we adopted the concept of fundamental breach. The idea that if the breach is intentional, in that case, then the breach is fundamental, just because it was intentional. And of course, Professor Schwenzer has written extensively on this point. This issue of intentionality of a breach is completely relevant to the CISG because fault is not an element. And even though the notion of fault may be immersed in Article 25, according to some commentaries, in reality it is not. The question is whether the breach is fundamental or not does not have anything to do with whether or not the party intended to actually breach the contract. And that is the difficult notion to accept for a French lawyer or Argentine lawyer or many other lawyers in civil law countries where they find that somehow the remedy has to be a sort of a sanction and not just merely compensation to the other party. So I think that's one of the points I wanted to bring to your attention. The other point that I thought it's important for you to see is that Article 25 works for both buyers and sellers. And the situation is somehow different. The way to actually understanding is to connect the notion of remedies with what are the obligations of the parties. And Article 30 tells you what are the seller's obligation, deliver the goods, the documents, conforming or conforming goods, and transfer ownership. That's the obligation of the seller. What about the buyer? Article 53 defines that obligations to pay the price and to take delivery. Now think about the notion of fundamental breach in the breach of any of these obligations. The breach can be fundamental if you breach any of the obligations, not principal obligation or any obligation. So if the buyer doesn't pay the price or doesn't take delivery, obviously that you immediately connected with a deprivation test and says, well, that obviously substantially deprives the seller of what he was expected to receive. What about if the seller breaches? Well, if the seller fails to deliver the goods, and in that particular case, then it's clearly that the buyer would have been the victim of a fundamental breach. But there are areas where it's not so clear. And that's one of them that you will hear today after lunch with Professor Schwenzer, when the goods are non-conforming. And that's a terminology that uses the CISG. No, the obligation is to deliver conforming goods. Conforming as to what? Conforming to the contract and to this convention. This is what Article 30 and Article 53 says. So the first thing you have to determine whether a breach is fundamental or not is according to the contract. And this is one of the important points that the advisory council, when was asked to think about this problem, thought about what are the elements to take into account and to guide arbitrators and courts to let them know when the breach can be fundamental and when not. And the first advice that the advisory council gave, it was an opinion number 5, and it was delivered in 2005. The rapporteur was Professor Ingeborg Schwenzer. She was very clear, and I think she made the point today also, that the first thing you have to look at is the terms of the contract. If the terms of the contract call for apple juice that has to be unsweetened, it's obvious that if the apple juice you deliver, no matter how good it is, if it's sweetened, it will be a fundamental breach if you don't get that. If the paper that you have to deliver has to have a certain volume of thickness, then if it doesn't reach that point, then probably that was likely to be fundamental because the contract says that, or because the judge or the arbitrators are applying Article 9, Paragraph 1 or 9, Paragraph 2 that speaks about the course of dealings of the parties or the trade usages, in that area understood that to be the case. Then, terms of a contract, you interpret it under Article 8 of the CISG, you interpret it in light of Article 9, you reach a conclusion that the seller could not have actually received what he or she was expected to receive, or the buyer. And I emphasize this point because when the Advisory Council thought about this issue, it thought in terms of what is practical to lawyers, because of course in theory it's very interesting to talk about fundamental breach, but what we found is that most cases and most disputed cases deal with the seller's breach for nonconformity and the buyer's remedy in that case. And this is why, and I think that if you have the opportunity, it's interesting for you to see the sort of a protocol followed by this advisory council that now has 12 members, and it has varied in composition and try to be, as you can see, integrate people from different legal cultures with command of different languages and different legal systems. And this opinion is interesting, was one of the few that the advisory council received from someone who asked for the question. In most cases, the advisory council said, if we receive a question from any institution and we think that the question is relevant because courts all over the world have different views on it, then we will have an opinion on that. Otherwise, we won't. And it was the New York State Bar Association who in 2005 asked the advisory council specifically on this question about when the buyer had the right, in the case of delivering non-conforming goods, to avoid or terminate the contract because of fundamental breach. So it's one of the few, as I said, reports in which the advisory council responded to this question. And I think that the issue of which are the elements to be found, the terms of a contract are the first one. The second one is, what about the gravity, the seriousness? What is the amount of damages that it cost to the buyer, the fact that the seller delivered non-conforming goods? Would that be relevant or not? And after much thinking about it, the advisory council reached the conclusion that it's really what is important is not to determine in the abstract how serious was the breach, but to determine actually more pointedly what was the interest of the promisee, either the buyer or the seller, of what was the interest in receiving what he expected to receive. In other words, it's impossible to respond to the question of whether the breach was fundamental or not unless, in addition to the terms of the contract, you think, what is the purpose of the contract? What did the parties intended? If the goods were meant to be used for machinery, for business people to produce certain goods, then it's a different situation if what the buyer wanted was to resell the goods. Because if the idea is to resell rather than to use the goods, then you may think about what if the goods do not conform to the contract. Would have made it impossible for the buyer to actually resell the goods or not? And on that point, there are enormous variety of fact situations that you may encounter on this possibility. But you need to focus, again, I repeat, terms of a contract, purpose of a contract. Was it for use? Was it for resale purposes? Or for what type of purposes? And then, and only then, an arbitrator or a court may be able to issue that a response to that. And for me, the issue came of interest because I want you to think and reflect when Professor Schwenzer talked today about the idea of uniformity, which is really the very goal of the CISG, to have one law applied and interpreted the same way, regardless of whether it's a Serbian judge or a German one or a Chinese one. And it's difficult because we judges are subject to their own legal culture and their own legal terminology. And reflecting on fundamental breach came to my interest because the Public Republic of China is very interested, having thousands of decisions on the CISG, probably is a jurisdiction with more decisions than the CISG. They wanted to somehow to give guidance to Chinese judges or to arbitrators applying Chinese law or the CISG to let them understand what standards they could use whenever they had to determine whether the breach was fundamental or not. And they First of all, the People's Republic of China came out with this idea that the Supreme Court is given the power to give interpretations of the law, including treaties, application of treaties. So the Chinese Supreme Court can give interpretation of the law, which really look very much like a rule. It would be definitely, in a common law country like the United States, would be an invasion of separation of powers if you give judges the power to give rules that are to be applied regardless of the facts of the case. What the common law stare decisis or binding force of precedent says is that you can apply one rule, but under a certain set of very specific facts. Otherwise, that rule doesn't apply. Well, interestingly, when I was asked by this Chinese colleague to look at this case guidance system, which it's aimed to orient Chinese judges how to use it, they focus on fundamental breach as one of the more troubling and disputed areas of the law, and they wanted to distinguish when the breach can be fundamental from when it cannot be fundamental. And the case guidance system, they already have issued several of these case guidance rules, but the case guidance system, in order to make it more understandable and usable by judges and courts, they give a very summary of the case in a standard sort of a fashion. And when I read that standards in the case of fundamental breach, it was a case in which there was a sale of oil, petroleum, and it was called the substance petroleum coke. And there was clear a breach because the contract called for some kind of thickness of the oil that was not reached by the goods that were delivered. And there were different opinions in China about whether that constituted a fundamental breach or not. And the Chinese Supreme Court came out with this guidance system saying to the other parties, well, if the buyer is able to resell the oil without great inconvenience, then the breach is not fundamental, which actually conforms to the idea of fundamental breach. Why? Because the idea of fundamental breach is that if you can repair the breach, or if you can compensate the other party by paying damages, or by having price reduction, or some other remedy, do not use fundamental breach. That is the last option, the ultima ratio. The problem I found in the decision of the Supreme Court of China that was meant to guide other courts was it doesn't actually tell us whether or not that oil was meant to be resold or meant to be used by the purchase, by the buyer. And I think the issue is important because it was implicit in the decision that that petroleum that was sold in China was meant to be resold in China, and that therefore the Chinese judge found that the breach was not fundamental because, after all, it could resell it at a lesser price that could be well compensated, the difference in price, with damages. My problem was that, the way the rule is worded, coached, is a sort of an abstract rule that if you don't have any problem in reselling the goods or don't have major problems, then the breach cannot be fundamental. I said to myself, well, that definitely, it's a rule, but it's a rule that is not part of the CISG. It's a rule that cannot be applied for all cases of fundamental breach. And it made me think in terms of what I can express to you, the relevance and the importance that when Serbian courts interpret the CISG, whatever the Serbian courts interpret and apply, that would be likely to be looked upon by subsequent courts or by arbitrators that are sitting in Belgrade and have to apply probably Serbian law to. And what standards would they use? They would probably use the standards that Serbian courts have used to interpret Article 25. Even though, of course, it's only one jurisdiction understanding, but it be important it would be definitely significant. How do your courts or your highest court in Serbia draft? What is the style of writing of judgments in Serbia? Do they describe the facts in detail, or are they more give a summary of the facts like we have seen in many civil law jurisdictions, and you end up with a rule that is being applied, but you are not very clear what were the facts of the case? This, I think, is a very important point. Why? Because when you cite and refer to the case law under the CISG, be aware that unless you actually are able to identify what were the facts of that case, the rule doesn't make sense in itself. it's better to go to a commentary or to some abstract commentary in that sense. And therefore, I thought about it because I've seen it many times when I have to work with foreign lawyers in the United States that sometimes they come and say, well, we would like to know about what the case method system is about. Well, of course, the case method system is based on the fact that cases are binding. But you cannot get to that point of what aspect of the case is binding unless you spend hours or years of legal education giving students full text of cases and not merely the abstract of the case. Well, that's what the students do in the United States. They actually go over full text of cases and they try to, and they necessarily and unavoidably have to tackle the questions of the facts and whether or not one case would have impact or relevance in another case. This, I think, it's an important point, and I definitely stop here, Marko, to give questions, which is what I would really like to have, not only from the Mooties, if this has any relationship with the Moot case there, but any other student. How important is for you if your professors do not give you the full text of the Supreme Court decisions or the court decision to read them, because you as lawyers will have to do that in any event. And what is binding or what has an impact of that case in a subsequent case, of course, will depend on whether your judges do read cases, precedents. But in most legal systems, on one way or another, it will be a very strongly persuasive argument if you tell them, under the same facts or the same relevant facts, this was what was decided. You should do the same, at least on the basis of principles of equality. That's the point I wanted to make. And I know my time is off, but I do have times for questions. Anyone, please.
Professor Garro, what you have just described and asked the question, and you basically answered it. Yes, our courts write sentences, the judgments, in a way which would at best be described as cryptic, and at worst as confusing. And I think everyone who sits here in this room and has attended any sort of, I would say, practical skills or lectures, and my colleagues here, they nod enthusiastically when you said that. So the problem we have is twofold. First, luckily, the binding part of the judgment here technically is just the holding. So we have a very narrow concept of the binding force of the judgment. Of course, this is in theory. In practice, a certain quasi-precedent is enforced throughout judiciary, for lack of a better word. But it's very difficult to understand when we read our cases. I can say that it's very difficult to understand what exactly were the facts, because you either don't have the full picture, or you have the full picture but you don't understand the reasoning. You just have a slam at the end and something happens and then you have a holding. And I wouldn't say that arbitrators here, they look for court interpretations of Article 25, if there are any. I think most of our CISG practice is in arbitration. I don't remember what the practice was in that article we have co-written.
Article 25 has not been raised on many occasions in the practice in Serbia that we have analyzed. There were cases dealing with non-conformity, but not necessarily Article 25 and the avoidance on that basis. Funny enough, one of the best court decisions from Serbia, from a district court from Čačak, let's say, which interprets the issue of non-conformity and avoidance of contract perfectly under the CISG, is based on a contract that expressly stipulates that CISG is excluded. It was, of course, it's no longer relevant. The higher court recognized the mistake of a judge, but I was impressed with the reasoning, although the judge should have never applied the CISG in the first place. But going back to some of the things that you have mentioned, I'm very happy that you have informed our students about the resale test, which I think is of great importance for the concept of fundamental breach, leading to avoidance and some other remedies that Edgardo will talk later in the afternoon, I assume, which show the tendency of the CISG to keep the contracts standing pacta sunt servanda, something similar to all of you studying here in Serbia, unless there are some aggravating circumstances that warrant for avoidance or delivery of replacement goods or so on and so forth. So it's not only what's written in the contract, it's not sufficient. I mean, the party's intention should be used as a source of interpretation when deciding whether something that's not in accordance with the contract is such that a breach of that provision raises to the threshold of fundamental breach. The element of resale has been used not only in China but in other jurisdictions, but it's not submitted to the judges as a hard rule. But I would like to question your foreseeability test statement. I mean, I'm aware that the foreseeability from Article 25, according to majority of the authors, is tied to the time of the conclusion. But if you all look at the text of the Article 25 and the last part, which contains the foreseeability test, you will see that the words at the time of the conclusion of the contract are not there. And then again, if you look at the preparatory work, drafting history of Article 25, you will see that this was debated, this matter was debated, but in the end, the drafters or the delegates decided to omit the reference on purpose and leave it for future purposes for the courts to decide whether some later point in time might be relevant for the foreseeability test under Article 25. And so here I am representing the minority opinion under the CISG scholars, but just so you know, the different interpretations of Article 25 are also possible.
Definitely, and I
Alejandro, I just wanted to make it controversial for the students to have an opportunity to hear the opposing views on some matters.
Of course.
And which also contradict to some extent what Ingeborg was saying at the earlier panel. But we all of us here working at the law faculty who sit at this table agree with you in entirety that using cases and full text of judgments is the best educational tool there is. Unfortunately, it requires a lot of reform of the legal education as it is here. We try to apply the approach that you're suggesting in some upper level, let's say, classes, study groups, and I see many students here who have been acquainted with this type of studying and learning, but it's not possible.
I think you should not give it to the later students. No, not to doctoral students. You should give the study and working with cases first-year law students. At the same time, you're teaching with them
first-year law students don't have law here. I mean, this is a legal reform matter of the education here. We'll discuss this later. But we have some second year and third year students
Please feel free. The questions are open. The floor is open.
While the students are asking, just one question to Professor Garro. Have you ever come across a court decision of a Supreme Court that quotes an international treaty that doesn't exist?
No, I have not.
We have.
It wasn't. I found the basic court, not the Supreme Court. Yes.
Yeah.
Appellate court says, well, it's fine.
Lisa, you have a question, I see.
I wanted to tease out one thing which we didn't get into, but in relation to the idea of what is a serious or minor breach and the idea of working that out. I mean, Milena mentioned before that, of course, we must look to the party's own intention in interpreting that, because what they think is a substantial deprivation influences what we might interpret actually fulfills that test. But also I'm just wondering now, because you mentioned, of course, the idea about, what has happened with the goods. Because now the CISG is interpreted as covering not only tangible goods but intangible goods, does the nature of the goods, do you think, influence that level of seriousness? I mean, because we don't then, if it's an intangible good, have the issue that underlies this of trying to keep the contract on foot because it's too costly to send the goods back. If they're intangible, that's not a problem, right?
Absolutely.
Yeah.
And I think that questions of the application of the CIG to intangibles is a whole world, digital assets and streaming and all there's a world to be discovered there. And I do think that, Lisa, that it's impossible not to take into account the nature of the goods either. And that's why I think the fundamental breach test is a complicated test, because in order to determine what is the party have been deprived of what he was substantially expected to receive, well, you got to think about what are we talking about? Tangible goods, or are we talking about something that is intangible? So I think that your point is absolutely well taken. I didn't pretend to say that it was just simply black and white test. It's a much more complicated test. Purpose of a contract, intention of the parties, terms of a contract, and obviously the whole contextual issue. Yes, absolutely.
Thank you very much for a lecture. I'm coming from Department of Social and Law Theory, so I have a theoretical question. What should be the difference between relevant facts of the case and non-relevant facts of the case? Are there any general rules or standards how to recognize them?
Fascinating question. There's no way to answer that question in a conceptual way. I would definitely tell you, well, relevant facts are those that are material, substantial to the outcome of the case. Otherwise, it would not be. What does that tell you? Not very much, right? But I think that is what the question that you asked and was so pertinent in order to reflect upon the issue that I just brought up to you. The only way to get a training about it is to specifically deal with cases, and this was a case of intangible goods. This other one was a case of tangible goods. This one was for the purpose of consumption. The other one for the purpose of resale. They are different. They're different outcomes. What do they make them relevant facts? And that would be the only way to answer that question. In other words, I definitely am not against theory, but the only way to get to the theory sometimes is with some inductive method by finding a lot of little things and then putting them together. That would be as if it would be so easy, right?
Any more questions, perhaps? I see a hand there.
Yes, sir.
Okay, so first of all, thank you for your lecture. I wanted to ask you about legal standard in the Article 25, which refers to the reasonable person from the Article 25. Now, it seems a bit weird because in international trade, we're always talking about corporate structures, which are usually very big because they're transnational transactions. So who is supposed to be that reasonable person? Is it the CEO, the signatory, the representative of the company, or is it just some employee that is, let's say, has a jurisdiction over that contract? Or is it perhaps the CEO who is supposed to, let's say, foresee the consciousness and the level of carefulness of his underlings and employees and so on. Thank you.
Thank you for the question, because I think that when the CISG, not only in Article 25, but in so many other articles, repeats the word reasonable person. And of course, if you have in mind a corporate structure with the complicated subsidiaries and affiliate companies that it happens, you may well say, well, what could have a CEO in that position would have foreseen at the time of the conclusion of the contract? The concept of reasonable person is so abstract. I don't know whether in your law of obligations you have a notion of bonus pater familias or some other type of Roman standard that is so sort of an equivalent of reasonable person. I think you would need to have to think about it in terms of in the abstract, being a John Doe abstract reasonable person. Because if you start to discriminate among the different decisional powers that is divided within a complex corporate structure, you may argue in favor of your client that the CEO could never have foreseen this, or that the other employee could never have foreseen that. Probably the response that you're going to get from the court of the arbitrator is, I'm sorry, I'm going to use a reasonable standard person as an abstract concept. What would a person, not necessarily a legal entity, an individual person, would have foreseen at the time if doing business in that area? Definitely, I don't deter you if you are defending the position of a client who has a complex corporate structure to tell the judges or the arbitrators, well, this would be very difficult in our company to have foreseen that, because this is our method of actually calculating damages. And I think that would be a very good point. But definitely, the reasonable person standard of Article 25 is no different from the rest of the convention. Very abstract. In the abstract, what could a person under similar circumstances in the trade concern? That would be no more than that.
Thank you. Do we have some additional questions, perhaps? If not, I should thank Alejandro for this
Thank you very much.
Truly excellent presentation.
Thank you very much.
We will now take a break, so we reconvene at 5 o'clock at the Amphitheater 4 to hear the 3 remaining presentations. You're free until 5 o'clock. Thank you.